So, what's going to happen with Lisa Marie Presley's estate? My name is Andrew Ayers. I'm an estate planning and business law attorney. I've got offices in Edina, Minnesota, and New York City. And today we're going to take a look at the latest celebrity estate to make it into the news. So, as commonly happens when a celebrity dies, the news immediately looks to what does their estate plan say, or what do they leave behind. Now, in well-crafted cases, we don't actually find anything out. A lot of celebrities will use a trust and use advanced planning techniques to make sure that their private affairs stay private and don't end up in the paper. However, we've recently run into situations with Tupac's estate, dealing with NFTs. We've dealt with Anne Heche's estate, and one that hits home closer to Lisa Marie Presley, Naomi Judd's estate in Tennessee. So in all of these cases, what happens is there's court filings because there was some kind of a problem with the documents, and that's no different here for Lisa Marie Presley. So when I read the news, the first thing I tried to look at is what's going on here. And what's going on is that apparently in 2016, Lisa Marie Presley created an amendment to her trust that removed her mother and her business manager as the successor trustees to her trust. What that means is that she was the trustee of the trust. She was managing the affairs of the trust, but if something happened to her, like in this case when she died, her mom and her business manager would have taken over. However, in 2016, this was allegedly changed so that she replaced her mom and her business manager with her two oldest children, Riley and Benjamin. Now, Benjamin died in 2020, so at this point, Riley would be the only successor trustee left. Now, Lisa Marie also has two twin daughters, age 14, from another marriage from her last husband, and they're not apparently mentioned as trustees in this document, and that's a good thing because under the age of 18, it wouldn't be proper trustees at this point. Now, the amendment was done in 2016, but apparently Priscilla Presley, her mother, has some concerns about this. Now, Priscilla's filing to contest the trust amendment on three different grounds. First of all, she says that the alleged document actually misspells her name. Second, the signature doesn't look like her daughter's signature. And third, there is no witness or notarization of this amendment. So, as a lawyer, when I'm looking at this and I hear these are the three grounds, I immediately think there might be something going on here. Because we're also finding out that so far there's been no will filed, so we're not sure if there's any other estate planning document out there that would help us maneuver this situation. But without a will, that trust is going to be the operative document, the document that controls what happens to Lisa Marie's fortune. Remember, she's the only granddaughter of Elvis Presley. This is an important estate that we need to understand about. We're also figuring that this is probably just going to be the beginning of the news about this estate. For just starting with the trust amendment, we could have lots of other things down the road coming up. Here in Minnesota, we've had that for years with Prince's estate. He died in 2016, and even 7 years later, there's still proceedings going on to determine who's entitled to what under his estate. So if I'm presuming the news is true, that everything I've seen in the papers and seen online is true, then we have a few things that Lisa Marie should have done before she died. So let's look at that trust amendment and look at what she should have done to figure out what the proper way to do it is. First of all, she needs a valid will. She has twin daughters who are age 14. They're under the age of 18, and we need to make sure that we have provisions for their care. Now, it seems that the father is still alive, so maybe we're not as concerned. However, when you have parents of a child under 18, you want to make sure you have a will that has, first of all, guardianship provision, so who would take care of them if you die before they reach the age of 18, and second of all, some kind of a trustee to be able to manage their finances, to manage the money for those young children. Now, without either of those, I would be concerned on behalf of her 14-year-old twin daughters that we don't yet have a will showing who should be the guardian and frankly who should be the trustee managing their money. Presumably, the trust that she had set up, the one that she tried to amend, hopefully has provisions for these 14-year-old twin girls, but if it doesn't, then we're having a big hole in this estate plan. The second, if we're going to amend a trust, let's make sure we do it right. Each state is different as far as what the requirements are when you want to sign a document in an estate plan. Some documents need to be witnessed, some need to be notarized, some need both. But when I hear about a document that was supposedly signed without a witness, without a notary, that usually leads me to believe there's something going on there, because a valid document almost always needs at least one, either witnesses or a notary, and in most cases it's good practice to have both of them present. Third thing I would do that's different is make sure you review your documents for spellings. So I think Priscilla raises a good point. If this is a document prepared on behalf of her daughter, why would her mother's name be misspelled? misspelled. And in this case, someone as famous as Priscilla Presley, you would assume that Elvis's wife, her name is well known enough that you would have it spelled correctly in these documents. So when we look at these three different things that could have been done differently, they would have alleviated probably most of the need for any legal proceedings in this case. If we had a valid will to protect those young children, if we had this trust amendment properly signed and also reviewed to make sure that mom's name is spelled correctly. So if you've got an estate plan and you're worried about making some changes, you want to make sure that you're doing them correctly. There's two ways you can do it. You could try to do it yourself, which it really sounds like that's what Lisa Marie Presley tried to do in this case. If she didn't have witnesses or a notary, she might have just tried to draft this on her own. But the second way to do it, the smarter way to do it, is work with a professional. Work with your accountant, your financial advisor, work with your attorney to make sure your estate plan documents are being amended in the correct fashion. If you aren't sure where to start or you want someone to talk to, you can go to my website, andrewmayers.com. There's a red legal strategy session button on the front page. If you click that, you'll be taken in my personal calendar where we can set up a legal strategy session. It's about a 15 or 20 minute phone call where we can go through your questions and make sure we've got you going in the right place, in the right direction. We want to make sure you know the next steps for you and your estate plan. And if you found this video to be insightful, I'd love you to hit that like button. If you want to see more like this, you can hit the subscribe button, and I look forward to seeing you in the next video.